All right. Did you talk to her at all, Mr. Werber,
We
today?
did, and we have resolved the matter, Your Honor. We'd like to place our resolution on the record.
Go ahead.
Thank you, Your Honor. The parties have agreed to enter into a consent judgment with installment payments. The total amount of the judgment, which includes the court costs, is
Today's courtroom session starts with confusion, missing paperwork, and defendants struggling to understand serious debt lawsuits. One woman openly questions why she is even being sued, while the judge calmly lays out strict trial deadlines and legal rules. This docket quickly turns messy, emotional, and unpredictable. Subscribe now for more courtroom breakdowns and drama.
All right. Discovery concludes June 18th. No motions heard on the date of trial. All motions have to be filed. All motions for summary have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury. Witness lists are due on May the 8th. I'm going to put down 1/2 hour for trial. Trial date will be on July the 27th. July the 27th. At 10:30 a.m. You don't have to file a trial brief. If you do choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. And you are all set. Anything else, Ms. Francis?
No, Your Honor.
Ms. Taylor, any questions, ma'am? Here you go, see.
Yes, I do. I'm just trying to figure all this out and why I'm being sued by someone I do not owe monies to. It's just also new for me, so I'm just really baffled at this point.
I don't know why. Listen, I don't know anything about the case. I cannot answer that. They've sued you on a debt. You're saying that they didn't produce the original contract. You can talk to them, explain to them why you think this is a fraud, if that's what you're saying, and you
Correct.
can go from there. Okay? We'll
Okay,
work it
thank
out
you.
as we go along. Thank you very much. Have a great day.
Thank you, Your Honor.
Michael
Thank you,
Bates Chevrolet versus Lauren Vander and Donk. 2505215.
Morning, Your Honor. Diane Roy, Michael Bates Chevrolet.
Your name, ma'am?
Kelly Wise, Michael Bates Chevrolet.
What has happened here?
So we sued Lauren for monies owed.
Yeah, why weren't you guys here March 17th?
They were here, they weren't here. We won it as a default judgment, Your Honor.
Jennifer, can you look at your notes from that day, please?
Yes, Your Honor, give me 1 second. I believe that if I understand it correctly, I believe the plaintiff was here, defendant failed to appear at one point. Then the defendant filed a motion to set aside the default, which was heard on March 17th. And plaintiff wasn't at the motion to set aside.
Correct. So you guys weren't here at their motion set aside, so I set it aside and I rescheduled this for hearing.
We were here, Your Honor.
No.
He had a judgment.
Wait.
The first case you called that day.
Okay. You were here on January 27th.
Correct.
I entered the default judgment.
Correct, yeah.
They filed a motion to set aside the judgment. She did. You didn't show up on March 17th.
I got nothing for that, Your Honor.
Can you double check our certificate there? I mean, it's right on here. Motion to set it aside, March 17th, 1:30.
Yeah, and the notice was mailed on 2/6 to the same address that the notice was just mailed for this hearing.
You see what happened?
No, I don't. I'm sorry, sir. I don't.
We did mail it to you.
Okay, I didn't get it.
She's on February 6th. She's saying. Did we ever get it back, Jennifer?
No, Your Honor.
So I'm confident we mailed it. Maybe you guys lost it. Maybe the post office threw it in the Franken Poet drain. I don't know, but
This is the only thing I have was today's that we got. This is the first thing we received.
we mailed it. I'm just telling you. And now we don't have Lauren Vanderdonk here, right?
I thought that it was on Zoom. They're on Zoom now.
Are they on Zoom, Jennifer?
No, Your Honor.
Okay, now, it's not. Can I see the docket, please? I just don't want this to keep going like this. 8:30 a.m. I gave her 15 minutes. Has the defendant made any payments on this account since you were in here?
Yes, sir. They arrived at the store one day and she did give me $1,500.
I'm going to ask you to raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes.
All right, so you sued. I initially gave you a judgment in the amount of $6,361.60. She's made $1,500 worth of payments since then.
One time, yes, correct, sir.
So the principal sum then, instead of being 62,1660, should be, correct me if I'm wrong, 47,1660, correct?
That's correct, Your Honor.
And then you have court costs of 75 and 70 in terms of filing and service fee. And then you have a total judgment therefore should be 48,5660, correct?
I didn't have it, so I'm sorry.
Yeah, that's it. So I'm gonna go ahead and enter a default judgment. I hope this is the last I'm gonna go through this. So judgment is entered, 4,856.60. You can go down the hall and they will give you a copy of the judgment, okay? Have a good day. Thank you. Capital One versus Melissa A. Koski, 2600108.
Good morning,
morning.
Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Good morning, Mr. Werber. Ms. Koski, your name?
Hi, Your Honor. This is Melissa Koski.
All right. Did you talk to her at all, Mr. Werber,
We
today?
did, and we have resolved the matter, Your Honor. We'd like to place our resolution on the record.
Go ahead.
Thank you, Your Honor. The parties have agreed to enter into a consent judgment with installment payments. The total amount of the judgment, which includes the court costs, is $2,057.45. The defendant is going to make monthly installment payments of $50 starting on or before May 15th, 2026, and on or before the 15th of each month thereafter. I did provide her with instructions on how to make payments directly to my office. The defendant is willing to give me consent to sign her name to that consent judgment and get that filed with the court.
Thank you. Do you understand everything Mr. Werber just said, Ms. Koski?
I do.
He tells me that you are agreeing to a consent judgment in favor of the plaintiff against yourself. Total judgment amount, $2,057.45. If you, in the installment payment provision will provide that you have to pay $50 per month beginning May the 15th of 26 and the 15th of every month thereafter until paid in full. If you miss a payment, there's going to be language in that judgment which would then permit them to set aside the installment payment order and proceed with garnishment of your wages. They cannot garnish your wages so long as you make these payments as agreed upon. They could, if they wanted to, garnish tax returns. Do you understand? And garnish bank accounts. Do you understand that?
I understand, Your Honor.
Do you agree to all those terms?
I do.
Does Mr. Werber have your permission to sign your name to that proposed judgment?
Yes, Your Honor.
Okay, you're all set. Thank you, Mr. Werber. Any questions, ma'am?
I'm okay. Thank you.
Good luck. Thanks a lot.
Thanks, Your Honor.
Thank you. All right, Absolute Resolutions versus Tiffany Holly, 2600114. Good morning, Mr. Burke. Your appearance?
Good morning, Your Honor. Hal Burke, P69068, attorney for Absolute in this case. And I'm happy to say the case is paid in full. Ms. Holly and I had a productive conversation in the breakout room.
This moment is critical because the defendant agrees to a consent judgment with monthly payments, avoiding immediate wage garnishment. The judge makes it crystal clear. Miss those payments, and creditors can move aggressively against bank accounts and tax refunds. Would you risk signing an agreement like this under financial pressure and stress?
Ms. Holly, your name, ma'am?
Yes, Your Honor. Tiffany Holly.
All right, so we adjourned this on February 24th because I was told that you were going to pay this in full by the end of March. Are you going to submit a stip in order to dismiss with prejudice?
Absolutely, Your Honor. She made her last payment. I'm told by her and by Absolute on March 31st. I'm surprised it hasn't been filed, but it will be today.
Okay, so ma'am, and just, you understand what's happening. You paid this, he's going to dismiss the case with prejudice. He has to have permission to sign your name or else he has to send it to you. Does he have your permission to sign your name to the proposed stipulation and proposed order dismissing the case with prejudice?
Yes, Your Honor.
Okay, so I'll wait for that. I'll ask you to get that to me in the next couple of days. Mr. Burke, anything else?
Nothing further. Thank you, Your Honor.
Have a great day. Ms. Holly, good luck. Thank you.
Thank you, sir.
All right, what else?
It's 5 to 9, so.
Why don't you give me the 9 o'clocks, and if somebody's here, I'll call them.
Judge, I don't have any matching parties yet.
Good morning. How are you? Good. All right.
So the judgment?
I gave it to you. So we don't have Speckled Frog Learning Center versus Vanderpool here.
I have Capital One and Herring, or Herring, Devin Herring. It should be probably the last one on your stack there.
Capital One versus Devon Herring, 2600483. Good morning, Mr. Saloon.
Good morning, Your Honor. For the record, William Saloon, P41487, appearing on behalf of plaintiff.
Herring, you have to start your video, unmute and state your name, please. Or Ms. Herring, I'm sorry.
Hi, my name is Devin Herring.
Good morning.
Good morning.
So we adjourned this 2 weeks on April the 7th, or
Yes.
April 7th, I should say. That was back on March 24th.
Mhm.
Have you had any further discussions with her?
Your Honor, I don't know if she's contacted our office. I didn't notice that there were any discussions when I looked at the notes.
All right.
I could be wrong. I don't know if Ms. Herring can elaborate.
So I actually found out within this last year I was involuntarily hospitalized and found out that I have bipolar disorder 1. So I'm waiting on my Social Security disability, and I was manic when I spent that money as well. So that's what I'm waiting on now, is to see if the state of Michigan is going to consider me disabled or not, because that's what's preventing me from working.
Okay. Here's what we can do, ma'am. You file a document, an answer to complaint, where you acknowledge that the debt referenced in the complaint relates to your account. The amount that they're claiming here is $3,708.08 plus costs and judgment interest. What you can do, and I see you're saying you have no money to pay the debt, but what you can do is you can agree to a consent judgment. If you want to, I could put you and Mr. Saloom in a breakout room. And then I can swear you to an oath, and I can conduct a creditor's exam right now and make a determination as to how much you can afford to pay. Does that sound reasonable to you?
Yes.
So do you want to go into a breakout room with her, Mr. Saloom, and try to work out a payment arrangement and explain the consent judgment terms, and we can go from there? And then if you don't resolve the issue as to how much, what the installment payment provision should read like, I'll be glad to go ahead and decide that.
Sounds good, Your Honor. Thank you.
Okay, so we're going to put you two in a breakout room. Thank you both.
Yep, thank
Sure.
you.
Do I have Rebecca Sislow here by chance, Jennifer?
They're in a breakout room, Judge.
So the lawyer for Midland and
Yes.
Okay.
Yes.
What about One Main versus Hardacre?
She's in the courtroom.
Okay, is One Main Financial Group here? Somebody for
I am
them?
bringing them in right now.
Okay, ma'am, you can come right up here. And if you'd like, I see you're on Walker there. You can go ahead and have a seat right at the table or wherever you'd like, okay? So this is One Main Financial Group versus Kimberly Hardacre. And this is file number 2503497. Good morning, Mr. McNeely. Your appearance?
Christopher McNeely, P 45664 on behalf of the plaintiff.
Ma'am, your name? You don't have to stand. If you want to sit, if that will make you more comfortable, I have no issue with that. So just take your time. How much is the amount of this debt, Mr. McNeely?
$3,437.55.
Do you agree that you owe that amount?
Not that amount, I do owe that.
All right.
I'm paying payments, and then I try to make payments arrangements with that.
Well, I can do that for you. Okay,
I understand.
I understand.
So.
They can't garnish those as long as you keep them separate. Yes, slow down. Mr. McNeely, I hate to have to send her to a room where she can Zoom with you. She's got a medical issue ongoing here. Do you want to tell me what give me the whole breakdown as to how much is owed here, if you would?
So the damages are $3,437.55. Court costs are $77.25 for the filing fee. And I better write this down as well, Judge. Sorry.
It's okay.
$20 for a alternate service fee. There's some other fees for certified mail and whatnot that I'm not going to put in there. The process server fee for posting it was $44.72. My client does charge a $75 statutory attorney fee. However, my client has stopped interest from accruing on the account as soon as they sent it to my office.
All right. So you have all those figures together. You got 20 plus 75 is 95 plus 44 is 139.72 plus 77.25 should be 213.97. And I want you to stop and correct me if you think I'm wrong. So your total here should be.
The courtroom gets tense as the judge carefully calculates every fee, court cost, and service charge live on record. Even after disputing service issues, the defendant ultimately admits the debt is valid. That admission changes everything because the case instantly shifts from denial to negotiating repayment terms under court supervision and pressure.
Should be 36.51.
I got 36.54 and 52 cents.
Okay, ma'am, do you agree that you owe that amount?
He said he served me. He never served. I got something.
Because they filed a motion for alternate service, but they had the process server go out a few times before that. Then they had to submit the motion. So you were properly served. They are entitled to that.
Oh,
Okay, so do you agree that you owe that amount? That being said,
yeah, I don't know that far. You know, the original loan was 3,000. I paid.
okay, just keep your voice up for me.
I paid the original loan was 3,000. I paid 17.
Okay, it doesn't matter.
I
The interest was accruing.
got you. Understand.
Do you have any reason to dispute that you owe the listen to my question. Any reason to dispute that you owe the $3,654.52?
No.
Do you wish to enter into a consent judgment with Mr. McNeely along those lines? At which point we can conduct a hearing with regard to installment payments right now if you can't agree. Do you understand that?
Yes.
So do you wish to enter into a consent judgment with his office? And does he have your permission to sign your name to a proposed consent judgment that will be submitted to the court indicating that you owe in a judgment $3,654.52?
Yes.
Okay. Now, I'm gonna ask you to raise your right hand. You can stay seated there. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. So I'm going to ask you to prepare a separate consent judgment and then an installment payment order, Mr. McNeely. Ma'am, what sources of income do you have? Do you have any stocks, bonds? Nothing else, just Social Security disability. Okay.
I received that's 1993.
Okay. How much do you receive per month?
I received 1788.
What, do you have any questions for Mr. McNeely?
Not really, Judge. Unfortunately, my application says that she had income of $6,100 a month. So,
Say that again?
my application for the loan originally says she had income of $6,100 a month. So it's crazy that, you know, because they don't tend to lend money on just,
when did she make her application?
when was this originally? 2024.
Pardon?
2024, June of 2024.
Did you have $6,100? But let's just listen to my question. Let's just listen to my question. Did you have income $6,100 a month back in 2024?
It was joint.
Okay. Are you married?
No,
Well, who was the joint income with?
it was a friend, but one was screwed.
I'm sorry?
It was a friend, but they did not come through with what they were supposed to do. They were gonna help.
How much are you asking for, Mr. McNeely?
Would normally be $100 a month. Interest has stopped.
Yeah, I understand. Here's what I'm going to order, ma'am. You get your check on what? The 6th or 7th?
Third.
The 3rd. All right. $60 per month starting May the 10th and the 10th of every month thereafter until paid in full. 60 per month. And this order is subject to review. This order is subject to review on motion of either party. This order is subject to review on motion of either party. Just stop. I'll explain it in 1 minute. On or after November 1 of 26. So if you think you're paying too much, you can file a motion. If he thinks you're not paying enough, that you've got other income by them in particular, then he'll have the right, or his office will have the right to file a motion to set aside the installment payment order and increase the payments. Okay? Do you understand everything here? Yes.
Yes.
Okay. All right, Mr. McNeely, anything else?
What was the date, Judge, that it would be a review date? And it's only if one of us,
On or after November 1 of 26.
and it's
So
only
that-
if one of us files a motion.
Correct.
Very
On
good.
motion of either party, on or after November 1 of 26.
I will submit the consent judgment with signatures for both of us, signing for both of us, and a installment payment order that the court has ordered. So I'll just submit that without signatures at all.
Thank you very much. Ma'am, have a great day. We'll send you the orders, okay? Is your consent judgment going to tell her how to pay it? You're going to insert that in there?
You know what? Does she have email? Otherwise, we can send it by mail as well.
Sorry?
Email or
I heard you. I didn't hear her.
okay.
Give him your email address.
It's KIM
KIM
HARD
HARD
AC
ACRE
RE 37 gmail.com.
at gmail.com. Okay?
All right. Thank you very much, Judge. We'll send it
Have a
out.
great day. Thank you.
Too.
Capital One versus Devon Herring, 2600483. Mr. Salome, your name again, sir.
Yes, Your Honor. Defendant agrees.
By the closing moments, the courtroom becomes less about arguing debts and more about survival through structured payment plans. The judge balances firmness with compassion, warning defendants that future reviews and garnishments remain possible if payments fail. Like, comment, and subscribe for more dramatic courtroom stories, legal battles, and real-life consequences daily.